Mr. Isaac.
Please, Your Lordships, I appear on behalf of Mr. Taylor with my learned friend Mr. Miller. Mr. Smith appears on behalf of the respondents, Peter and Linda Jones and Peter Spriggs. My Lord, this is my client's appeal against the decision of Her Honour Judge Backhouse, made on the 7th of March this year. That decision was itself an appeal under section 1017 of the Party Wall, etc. Act 1996 and proceeded by way of rehearing. It was an appeal against awards made by a third surveyor under section 1011 of the Act, the third surveyor being Mr. Rob French. Both awards, since they both made on the same day, dated the 20th of August 2021. And in both of those awards, Mr. French awarded that my client was required to pay Mr. and Mrs. Jones and Mr. Spriggs compensation in the sums of £215,000 odd and £165,000 odd pounds, respectively. Those awards of compensation were made under section 7, subsection 2 of the 1996 Act, since this is a point raised by my learned friend, I'll deal with it immediately. It's suggested, I think, by my learned friend that compensation under section 7.2 is in some way qualitatively different from damages at common law, and I say that's plainly wrong, and the decision in Lee Valley and Derbyshire makes that point, and I'm happy to take your lordships to that if that assists at this point.
Well, in your own course, Mr. Isaac, we've obviously had the opportunity to read the judgment on more than one occasion, and the skeleton arguments. Thank you very much for that. And we've also been directed to the authorities and reminded ourselves of some of those and the more adventurous language that was once used. We're obviously starting from the position where the judge, Her Honour Judge Backhouse, made findings of fact.
Indeed.
So we can certainly take that as read, and we can move to the points that you wish to make, both as regards the nature of the compensation and the costs.
Indeed.
So where do you want to start? I mean, presumably you want to start with the nature of the compensation.
Logically, I think it comes first, even though I would note that from my client's perspective, the costs is the more important ground of appeal.
Yes, although there is some interlinking. I know you say that it's also separate, but there's some interlinking, isn't there?
Of course, I accept.
Yeah. But whichever way you want to play it,
very
Mr.
well.
Isaac.
I'll start then, since that was Ladyship's indication, I'll start with pre-existing damage and that ground, second ground of appeal.
Thank you.
So this ground concerns the extent to which what we say is the overarching requirement of reasonableness can be said to limit the dual requirements that firstly the defendant takes the claimant as he finds him, and secondly the principle of restitutio in integrum, putting the claimant back in the position he would have been in but for the defendant's wrong. I'll start, because it's the basic statement in the authorities bundle at tab 18, with the short extract from McGregor, the first paragraph of chapter 30, well, Chapter 39, paragraph 003, page 387 of the authorities bundle. The principal issue is whether damages should be measured by diminution of the value of land or by cost of reinstatement. The discussion which follows illustrates that this question is highly fact sensitive. However, the historical treatment by the courts of the distinction between the two measures reveals the relevant factors and guidelines which inform the appropriate measure. The overarching principle is one of reasonableness. It was never argued in this case that diminution in value was the appropriate measure. It was always a question of cost of repair, cost of reinstatement, and the question was always whether that requirement, that overarching requirement of reasonableness, required the court to have regard to, in terms of quantifying the damages, the existence and extent of pre-existing damage. If we turn to, I think it's probably best to start with what is the main authority relied on by the respondents and indeed by the judge, which is Harbert's plasticine. That's at tab 4 of the authorities bundle. Harbert's plasticine and Wayne Tank and Pump, 1970. Lord Denning gives the leading judgment. This was a case where a factory was burned down as a result of negligence of the defendant, who was installing new equipment in the factory. The claimant rebuilt the factory with insurance monies, and consequently had a new and better factory. Primary issue was whether the correct measure of loss was diminution in value or cost of repair, and there was a secondary issue as to whether a discount for betterment should be made. Before I turn to the specific paragraphs of this judgment, I would say that this is the judgment that is relied on not only in this case, but very widely in this area for the proper measure of compensation, and on the basis of what I would describe as the minimum reasonable necessary repair as being the appropriate test. Minimum reasonable necessary repair. And that is, we can see it paragraph, page 61 of the bundle. Lord Denning discussing this particular question. The destruction of a building is different from the destruction of a chattel. If a second-hand car is destroyed, the owner only gets its value because he cannot go into the market and get another second-hand car to replace it. He cannot charge the other party with the cost of replacing it with a new car. But when this mill was destroyed, the plasticine company had no choice. They were bound to replace it as soon as they could, not only to keep their business going, but also to mitigate the loss of profit for which they would be able to charge the defendants. They replaced it in the only possible way without adding any extras. I think they should be allowed the cost of replacement. True it is that they got new for old, but I do not think the wrongdoer can diminish the claim on that account. If they'd added extra accommodation or made extra improvements, they would have to give credit, but that's not this case. I think the judge was right on this point. So this immediately draws the distinction between necessary repair and something that goes beyond necessary repair and is optional improvement. Lord Justice Widgery, in relation to the same point, page 66.
But before we
Yes.
move on, so you're accepting that this is the distinction between necessary repair and optional improvement.
I'm saying that's the distinction being made in relation
and that's
to that
the principle
case.
from which we...
I would accept that's the starting point.
Yes, okay.
And this case is still good law, isn't it?
Yes, it's not, absolutely. It's relied on very regularly in this context. And it's fair to say that what we are trying to do in this appeal is to require the court to assess, in looking at that minimum reasonable necessary repair test, whether there are elements which are, first of all, properly necessary, and secondly, whether there should be a separate assessment of pre-existing damage, whether the issue of pre-existing damage, the existence of pre-existing damage, is an additional factor which goes into that that minimum reasonable necessary repair test.
Isn't that going to be fact specific?
To a large extent, I accept it must be fact specific. But the question is, and my proposition is, that it's not only fact specific. Obviously, findings of fact are very important in this regard. But there is potentially a principal difference between pre-existing damage and other damage for which we are liable to repair.
The other damage being accepted to be...
Indeed, the other damage being accepted to be caused by...
referable to the party wall.
Indeed.
Works. Yeah. Okay.
But if you're right that there is such a second point, betterment, in fact, doesn't that flatly contradict the paragraph you just read out from Lord Denning?
Well, this particular case, so Harbert's plasticine, was not dealing with repair of pre-existing damage. It was looking at ancillary betterment arising from in this case, the replacement of the factory. But it's a different point because you're getting something new and better. In the sense, you're getting a new car. Compared to an old one, you're getting a new building rather than an old building. But it's not, there was nothing wrong with this factory in the Harbert's plasticine.
Yes, but it's making the difference, isn't it, which you've already accepted, that in Harbert's case it was non-optional improvement. They had no other option open to them.
Yes. So, absolutely, I accept that is the starting point is the optionality or necessity of the repair.
And so in this case, cutting to the chase, if the judge found that the repairs that were undoubtedly called for as a result of the party wall works could only be effected because or by reason of certain other works having to take place, doesn't that fall into non-optional so far as the house owners are concerned? They can't affect the repairs unless they shore up.
Well, the findings of the judge were I'll take your ladyship to the findings on that point, because it's less than abundantly clear that the judge found it was a matter of necessity. She said as a matter of practicality it would be done.
Well, I think she went further than that, didn't she, Mr. Isaac? Because she said health and safety regulations meant that the repairs could not be effected unless, and that they would not be done unless the wall was shored up. And if she did find that, I mean, of course take us there, because I may have misread it, but if she did, then it's going to be the non-optional expense that...
Well, so my argument doesn't depend solely on the optionality or otherwise of the works.
So in a word, what does it depend on?
Ultimately, it depends on reasonableness.
Okay.
Because the question the court has to ask itself, and this comes back to the overarching point, the question the court has to ask itself is whether it is unreasonable in the sense of overcompensating.
But isn't it the other side of non-optional? If something is non-optional, then surely it's got to be reasonable.
Well, just because a repair is non-optional, necessary, does not mean that the claimant should necessarily recover the entire cost of that.
I see.
But let me I was just going to find the paragraph of the judgment.
110.
No, it's the paragraph that she is, and my lady Justice Macur was right. There is a reference to health and safety, as it were. Thank you. 63, I believe, is the correct paragraph. Yes. Theoretically, page 83, theoretically the remedial works to the internal walls and slabs could be done without underpinning the rear wall, but the expert's view was that no engineer would approve such a scheme on health and safety grounds, and no contractor is likely to agree to carry out the work in those circumstances. But it's not... Sorry. And also, my learned friend says, paragraph 101, final sentence, the unchallenged evidence is that in practice, the rear wall must be underpinned before the remedial works to the cross walls and floor slabs can be done.
But as my Lord Justice Bean pointed out, we should also put paragraph 110 into that list, shouldn't we, of the judgment?
Right now,
on the other hand, as in Harbert's, there's only one possible course of action. Underpinning the rear wall is the only possible way in practice of carrying out the other repairs.
yes, one can put that in. I expect one can put that in. And if one takes all of those together, it's very close to
All
saying
right.
necessity. I suggest we turn next to
You were about to show us what Lord Justice Widgery said.
I'm sorry.
In Harbert's.
Thank you.
All three members of the court gave judgments, but is there any relevant distinction between the principles?
Not really. Not really. They all take the same line.
Yes.
They all take the same line. So,
Maybe we should see how the others put it.
indeed, thank you. Lord Justice Widgery, this is page 66. At B, it was clear in the present case that it was reasonable for the plaintiffs to rebuild their factory because there was no other way in which they could carry on their business and retain their labour force. Plaintiffs rebuilt their factory to a substantially different design, and if this had involved expenditure beyond the cost of replacing the old, the difference might not have been recoverable, but there is no suggestion of this here. Nor do I accept that the plaintiffs must give credit under the heading of betterment for the fact that their new factory is modern in design and materials. To do so would be the equivalent of forcing the plaintiffs to invest their money in the modernising of their plant, which might be highly inconvenient for them. Accordingly, I agree with the sum allowed by the trial judges for the cost of replacement. And then Lord Justice Cross, page 69 now. At A, further, I do not think that the defendants are entitled to claim any reduction from the actual cost of rebuilding and re-equipping simply on the ground that the plaintiff have got new for old. It is not in practice possible to rebuild and re-equip a factory with old and worn materials and plant corresponding to what was there before, and such benefit the plaintiffs may get by having a new building and new plant in place of an old building and old plant is something in respect of which the defendants are not, as I see it, entitled to any allowance. I can well understand that if the plaintiffs, in rebuilding the factory with a different and more convenient layout, had spent more money than they would have spent, and had they rebuilt it according to the old plan, the defendants would have been entitled to claim that the excess should be deducted in calculating the damages. But the defendants did not call any evidence to make out a case of betterment on these lines, and we were told that in fact the planning authorities would not have allowed the factory to be built on the old lines. Accordingly, in my judgment, the capital sum awarded by the judge is right. So yes, there's no real distinction between those. They all take the same point in slightly different terms. Probably the most useful case of those in the authorities bundle in terms of analysing and considering this question is, I would suggest, the Baltic Surveyor case. That's at tab 9, starts at page 132. This was a case in which a ship, vessel, I'm afraid I'm not a shipping lawyer, so I'm not quite sure what the correct terminology is, which actually explains the problem in our skeleton. The plaintiff's vessel was terminally damaged by another vessel attached to a pontoon, also belonging to the claimant, and both the ship, the Baltic Surveyor, and the pontoon were in effect written off by by negligence on the part of the defendant in mooring his vessel. The issue which I want to concentrate on is the loss of the pontoon, and that is dealt with from paragraph 62 of the judgment onwards at page 145. And what the judge actually held in relation to the pontoon was that it would have cost £30,000 to replace the pontoon with a new pontoon of £60,000. I'm sorry, £60,000 to replace a pontoon of with new, like new for old, but the old pontoon only had 8 years life left in it, out of an expected life expectancy of 30 for a pontoon of that quality, and he therefore awarded 8/30 of the 60,000 by way of damages. You'll see at paragraph 63 that Miss Bucknell, the claimant, disputed the judge's approach as being wrong in principle and ill-suited to the facts of this case. She pointed out that the judge assumed that Miss Voden would have replaced the pontoon with just the kind of new pontoon, which he went on to find would have cost 60,000, and compared that with the cost of replacement of the trot mooring, which he awarded the full amount of. And we then move on to the Court of Appeals analysis of whether that approach was correct, whether it's wrong. And whilst I should say I accept that this is a discussion about the cost of replacement rather than the cost of repair as such, the similar principles apply as they do to cost of repair. It's the analysis in relation to betterment that I refer to here. So at page 149 of the bundle, paragraph 85 of the judgment, it follows that where a claimant recovers more than he has lost, as will happen where betterment occurs without a new for old.
I'm sorry, where are you reading from?
I'm sorry, paragraph 85 on the right-hand side.
Thank you. Yes.
It follows that cases where a claimant recovers more than he's lost, as will happen where betterment occurs without a new for old deduction, ought as a matter of principle to be exceptional. Recognised examples of such exceptions, again whether in contract or in tort doesn't seem to matter, are cases of the repair of chattels, the Gazelle, Bacon and Cooper, and also the destruction of buildings provided that a replacement building is necessary to prevent the collapse of a business or loss of profits. Harbert's Plasticine, Dominion Mosaics against Trafalgar Trucking. It may well be, therefore, that the distinction between repair and total loss relied on by the judge is not definitive, and that the exceptions are to be explained on a more fact-sensitive basis. A factor mentioned in some of these exceptional authorities is that otherwise the claimant is exposed to an inconvenience or burden or the expenditure of money from which the law ought to protect him, and that's what was mentioned in Harbert's. I suspect, however, that the true principle is that in the relevant cases the betterment has conferred no corresponding advantage on the claimant. Take the ordinary case of the repair of some part of a machine, where only a new part can be fitted or is available, the betterment is likely to be purely nominal, for unless it can be posited that the machine will outlast the life left in the damaged part just before it was damaged, the betterment gives the claimant no advantage, and in most cases any such benefit is likely to be entirely speculative. So in the case of replacement buildings, the building may be new, but buildings are such potentially long-lived objects that the mere newness of the building may be entirely by the way. Then if I could go on to paragraph 87.4, it is in any event an error to think in terms of the correct answer lying only at the extremes, such as at one end the cost of replacement from new. Several of the cases, even those which have on appeal been driven by the way in which the case has been argued to select the answer from a limited choice, have commented on this factor. In such circumstances, the test of reasonableness has an important role to play. This role goes further than the proposition that replacement from new has to be absurd for it to be rejected as the measure of loss. The loss has to be measured, and where what is lost is old and second-hand and coming towards the end of its life, it is not prima facie to be measured by the cost of a brand new chattel, even where the market cannot supply a closer replica of what has been lost, and where such measure would not be a reasonable assessment of what has been lost. It should not be used. as Mr. Justice May said in Taylor and Hepworth, cited with approval in Dominion Mosaics and Trafalgar Trucking and in Ruxley and Forsyth, damages ought to be reasonable as between claimant and defendant. I do not see why, in the realm above all of remedies, the common law cannot mould its principles flexibly to the needs of the situation, and as so often the test of reasonableness lies to hand as a useful tool. It may also be possible to speak in terms of proportionality, a closely analogous but not necessarily identical test. See Lord Lloyd in Ruxley and Forsyth. And the conclusion in this case is just at the bottom of that page, 8 lines up from the bottom. It seems to me that the approach adopted by the judge was correct in principle, and that to award £60,000 would have been unfair and unreasonable in such circumstances. It does not seem to me that it is open to this court to criticise the actual detail of the judge's assessment. So, in my submission, whilst that is commentary in relation to the cost of replacing old for new and limiting the recovery to that which is reasonable, there is no reason why that same principle should not apply to the cost of repair. It's merely two sides of the same common law coin. Are you obtaining diminution in value? Are you obtaining cost of repair? So if one applies the ultimate test of reasonableness to the question of should the claimant be compensated for the cost of repairing significant pre-existing damage, then whilst I accept it is still to a significant extent a question of fact, it is a factor which the court should take into account in determining the answer to that question. So
there's no finding, is there, here, that even if your client had done nothing at all, the walls would have collapsed within, say, 2 years?
there's no finding to that effect, but what there is there is evidence that our works caused 2 millimetres of movement, only 2 millimetres of movement, and that 2 millimetres of movement could be caused simply by seasonal movement during the course of a normal year. So, yes, it's true there was no finding as such that within a particular period this damage would have occurred in the sense of the dropping of the floor slabs.
No, but what was a finding about it, Mr. Isaac, was that the houses had had this fault, which was not related to the party wall's work, but that had been unknown to Mr. and Mrs. Spriggs, Mr. and Mrs. Jones, and that if it hadn't been for the excavations, there was no reason to think that they wouldn't have carried on decorating every couple of years, covering up those small cracks that were appearing. So, I mean, there is a difference, isn't there, between what you're saying, and you're very carefully saying there was evidence that there was a few millimetres that caused the movement. It was
I'm saying it was more than there was evidence that this was accepted and forms part of the judgment.
Right, but the judge also found that those householders didn't know about the extent of the damage that was uncovered, and also that they were entitled to assume, as they had done, that they could carry on living in the house if no works had been done that had caused this damage.
I'm not sure that the judge's findings go quite that far. It was agreed between the experts and formed part of the judge's judgment that there was very severe pre-existing subsidence, which had given rise to an 80mm crack in the back wall of the Mews cottages, that there were extensive voids under the floor slabs, that there was a crack, and this is the one that your ladyship has just referred to, at first floor level, which was filled from time to time, and that there was evidence of slight previous movement of the floor slabs at ground floor level.
Well, I dare say all that's so, Mr. Isaac, but did either the experts or the third surveyor go on to say, in my opinion, or I make a finding that this would all have collapsed within such and such a period?
No, they did not make that finding. What they did say is that even disregarding my client's works entirely, they would have said that those items of disrepair would have, should have been repaired anyway. In order to stabilise the building, so regardless of my client's work.
Can you show us what the judge says about that?
Yes, of course. So in the main bundle, she starts talking about pre-existing damage at paragraph 50. And she's summarising the experts' evidence. To summarise, they consider that the evidence points to subsidence beneath the footings of the rear wall prior to the construction of the intersecting cross walls of 5 St George's Mews and 6 St George's Mews, i.e. pre-conversion in the 1970s. This subsidence caused the horizontal DPC crack. The subsidence is likely to have been caused by a combination of desiccation of the subsoil by vegetation in the gardens of St George's Terrace and consolidation of made ground. A significant area of brickwork forming the rear wall above the 6 metre, because it's a 6 metre long DPC crack, is unsupported by the foundations. An arch developed in the rear wall to carry the wall over the crack. As part of the adaptation of the wall to the new loading conditions, a crack developed in the wall at first floor level in 5 St George's Mews, and it was that crack which opened up in February 2019. So that's the first 2 items of damage. At 52, in addition...
So February 2019, that means as a result of the excavation?
Well, certainly just after the excavation started. But this was a pre-existing crack.
Yes, but it widened.
Yes, it widened.
It widened, yes.
Widened and lengthened, indeed, over the subsequent period. In addition to dropping, the brick corbelling and mass concrete foundation below the DPC crack had rotated out about 30mm. This had occurred before the works. The voids seen beneath the concrete floor slabs also predate the works. They developed after conversion works in the 1970s and probably more than 10 years ago. The experts consider that the voids are extensive, including under those parts of the internal walls abutting the rear wall. And then at 54, the experts consider that the slight cracking around the boxing close to the ground floor bathroom of 6 St George's Mews, which was identified in the pre-work schedule of condition, indicates possible historic movement of the slab. So those are the 4 items that I've identified as pre-existing damage. In terms of the...
Sorry, what are the 4 items?
So the 4 items are the 6 metre long crack in the above footings level in the rear wall. The 30mm rotation of that foundation below the crack. Oh, sorry, that's part and parcel of the first one. The second is the voids beneath the concrete floor slabs. The third is the crack at first floor level, and the fourth is the cracking around the boxing of the ground floor bathroom, indicating possible historic movement of the slab.
Is the voids beneath the concrete floor slabs, is that, it's a pre-existing condition, is it damage?
Well, it's a pre-existing defect in that the floor slabs are supposed to rest upon solid ground.
Yes.
And so they are not. It's defective because it's not in its designed state.
Yes.
It's a defect which hasn't yet had a nasty consequence. So my point about the movement, and I take on board what my Lord Justice Nugee said in relation to there's no finding of a specific period in which damage would have occurred. But nonetheless, I point to, first of all, paragraph 60 at page 82. The experts agree that the movement caused by the works was only 2 millimetres. And over the page at paragraph 61, the last sentence of that paragraph, well, in fact, from halfway down that paragraph, Mr. Huband described the building as on a hair trigger. Mm-hmm. And a minor trigger could have initiated damage, such as drilling through the floor slab to fit a new bathroom outlet. Mr. Tant accepted, so that's point number one, is that this, just doing minor DIY work in the property could have caused the slabs to collapse. And then Mr. Tant, the respondent's engineer, accepted that 2 millimetres of movement could arrive just by thermal movement or seasonal movement according to climatic conditions.
Don't we have to look at the whole mechanism of movement, though, from paragraph 57 onwards, rather than just take out paragraph 60?
I'm not suggesting that we shouldn't look at the whole mechanism of movement. The whole mechanism of movement was that a tiny movement at either, well, at any point, but in particular at either end of this unintended arch, would potentially cause the damage which in fact occurred.
Well, potentially, but it wasn't that caused it in this case.
No, it's accepted that what
yes.
the finding in this case was
yes.
that what caused the hairline or the hair trigger in this case was indeed the work.
Yes, and the point I was putting to you very clumsily, Mr. Isaac, was based upon one of Mr. Smith's submissions, which was that the properties had been in a state of equilibrium. This is paragraph 110.
Yes. 110 of the judgment.
Yes.
Yes, so Mr. Smith's submission below and indeed here is that the properties had, although, one might say, despite the pre-existing damage, the properties had not suffered this, these further symptoms of that damage until my client's work.
Yeah.
Well, I wonder if that's an entirely accurate characterisation. As I understand the judge's findings, the wall was unsupported before the works. The foundations were not supporting the wall.
Correct.
The wall was in fact held up by an arch.
Yes.
So instead of being supported along its length by the foundations, it simply supported at each end.
Correct.
The judge also finds, I think, that had been stable for many years, so nothing had actually disastrous happened as a result, although, as you've pointed out, the experts agreed that it was on a hairline trigger. So there could at any stage have been a disastrous consequence of that, but that had not in fact happened. What actually happened was the excavation caused, as you say, a very small downward movement of the wall, only 2 millimetres. But that had the effect of breaking the cantilever, with the result that the floor slab, in number 5, I think, dropped by 40 millimetres, which is obviously a much more significant consequence. But that's not just a symptom of a defect, that's an actual damage, physical damage caused to the floor by, admittedly, the very unfortunate fact that your works caused the wall to drop by only 2 millimetres. But I think it's not quite right to describe that as just a symptom of pre-existing damage. It was a pre-existing vulnerability which was manifested itself when the excavation had that
I'm happy to accept that the collapse of the slab was itself damage, rather than merely a symptom of previous damage. Obviously, and yes, you're right to say that there was a pre-existing vulnerability that's mentioned in the judge's judgment. But I say there wasn't merely a pre-existing vulnerability. There was a pre-existing vulnerability, but there was also pre-existing damage. So the 4 items that I mentioned, and most obvious amongst those, are really the crack in the subsidence of and crack in the rear wall. Because by any account, that is damage itself.
Yes.
And there is a severable cost, I say, of remedying that damage. And my overarching submission here is that it is unreasonable to require my client to repair, fund the cost of repairing damage which not only pre-existed, but of which, if the respondents didn't have actual knowledge, they had constructive knowledge. Because
sorry. You described it as a severable cost.
yes,
but doesn't that beg the question? If it's something which could be left out, if it was possible to repair the damage directly caused by your client's works while leaving something else because it doesn't need to be done, then that's true betterment. And as I understand the cases following Harbour, the tortfeasor doesn't have to pay. But if it's not severable in that sense, then you're in greater difficulty, aren't you?
again, I would have to accept that it's a question of fact and degree.
Yeah.
But you'll have seen we've looked at the reference already in the judgment to the fact that in theory this could be done separately. In practice, for health and safety reasons, engineers would not want it done, would not want the other works done separately, and contractors wouldn't want to do the work. But that doesn't mean that from the perspective of reasonableness between and the reasonableness of recoverable damage, that shouldn't be a factor taken into account.
Can I be sure I understand what you say? The separate, theoretically severable, even if not practically severable, work consisted of. I understand that one of the pre-existing bits of damage is the 6 metre long crack in the wall, and presumably the works contemplated by the judgment will involve filling that crack.
Well, more than that. So the works contemplated or proposed for remediating the whole damage includes underpinning and repairing that rear wall and indeed the cross walls. But for these purposes, I can restrict my submissions to underpinning and repairing the rear wall in the sense of remedying that pre-existing damage.
Well, I think I need to be clear what it is you say the damage was, because I understand that a crack in a wall is damage, but I think you want to go beyond that. You want to say the fact that the rear wall was unsupported by its foundations and there were voids under the floor slabs. You say that's.
I do say that is itself damage.
And is being remedied by the underpinning.
Yes, that is being remedied by the underpinning.
But that's a consequence rather than the underpinning is not, as it were, optional. Going back to that word again, it's not that the householders are saying, now we know that there's a crack in the wall, we don't want the crack in the wall, and therefore we're going to use this as an opportunity to get the repairs done for free. Their case was, this has got to be done in order to effect the repairs that the judge has found flow from the party wall.
I have to accept that.
So the fact that the crack is going to get filled isn't an optional extra to the underpinning, is it? It's necessary for the underpinning.
Well, I'm describing both filling the crack and underpinning that rear wall as.
And the judge was aware of that because she says in her judgment, doesn't she, that it's the underpinning and the other works associated with it and other associated repairs, paragraph 108. When she's referring to your arguments, Mr. Isaac.
Indeed.
He characterises the damage caused by the works as secondary to the pre-existing primary damage. A's case is that he's not liable to pay for the works to the repair that pre-existing damage, which is independent of the works. The underpinning of the rear wall and other associated repairs is not a necessity arising from the damage caused. So she had well in mind your submissions.
I absolutely accept that. But my fundamental submission remains unchanged, which is that in determining what the appropriate quantum of damages or compensation to award in respect of repairs, the court can and should have regard to whether it is reasonable in all the circumstances to require the defendant to pay for the cost of repairing pre-existing damage. And it should not be simply a question of what is the minimum reasonable necessary repair. Just to illustrate and I accept that this is a difficult task for a judge to determine, but well within their capacity. A very common scenario in a party wall context is that an adjoining owner's property, let's say they have a living room adjacent to a party wall that is in a tired state of repair with some cracking to the walls. Notifiable building works are undertaken next door, and a new crack appears on the party wall. What then is the appropriate repair for that crack? Is it to simply repair the new crack? Is it to repair the new crack and the other cracks? Is it to repair all of the cracks and to redecorate the one wall on which the new crack has appeared, or to redecorate the whole room? That's a common scenario in these cases, and one might say that it is possible to simply say, well, what is the minimum reasonable necessary repair? I'm going to decide that it's any one of those answers. Or one can say, well, actually, there's a fairly high level of pre-existing damage here, and so it would be appropriate, and it would avoid overcompensating the claimant, the adjoining owner, to only award a proportion of those costs. So that's a very common scenario, closely analogous to where we are here. And my overarching submission is simply that where there is pre-existing damage, the minimum reasonable necessary repair is an oversimplistic approach to assessing the appropriate quantum of loss.
You've already accepted, Mr. Isaac, that the judge made no finding as to how many years would elapse before the homeowners would have been forced to carry out repairs to the arch, the underpinning. So, was there any exploration with the experts about that during the course of the cross-examination? And if not, are you in difficulty? Because if you're running this case of pre-existing damage, which is going to result undoubtedly in the necessity to do some works at some stage in the future, how is a judge to determine, as they did in the pontoon case, what percentage of the cost should be attributable to the pre-existing damage that's going to become necessary to repair in 2 years or 3 years or 4 years or whatever?
Well,
this judge had nothing to go on.
Well, with respect, I'm not sure that it was necessary for the judge to have a particular time scale in mind. If it was clear already that those works were necessary, because
But when? Because this is the thing I was talking about. If the householders were saying, well, we had no idea of the extent of what's now being revealed, but all we can say is that there's been no indication whatsoever prior to today's date that we would have to have these works done, and it's lasted so long, so how much longer is it going to last? Well, they weren't given any answer by the surveyors.
Is that would appear to be rewarding the claimants, I'll describe them as the claimants, the adjoining owners, for failing to investigate?
No, not at all. It's perhaps it's providing a critique of the failure to lay the evidential basis for the case that you're putting now, which is if that this had been known, then like it or not, the house owners or house occupiers were going to have to repair this damage in any event within, and therefore the judge was entitled to take a proportion of the cost.
Well, the evidence was that the moment they knew about it, they would have had to repair it. That's the way I put it.
Oh, that's the way you put it. Where's the finding?
So that comes from the sorry, I've got to find the reference. Sorry. Yeah, so paragraph 62. In terms of remedial work, the experts consider the remaining part of the rear wall needs to be underpinned, which is preferable to stitching. That would have been their recommendation had the damage to the walls and slabs not occurred. So it would have been their recommendation to do those works, to underpin that rear wall, regardless of whether my client had even carried out his work, once it was known about. So I would suggest, respectfully, that the position is even stronger than it would have. The damage would have occurred in 2 years, 3 years, or whatever point in the future, because the reality was that in its state as it was then, it required repair. So in its state, pre-works state, the adjoining owner's property required repair.
Well, it says in terms of remedial work, which is obviously work that takes place after the damage has been caused.
But
the damage has been caused by the party wall works.
But this is remedial works to the rear wall. The rear wall didn't change in any significant way. The rear wall remained as it was. There's a slight extension of cracks at first floor level, but the rear wall fundamentally did not change significantly. Its state of repair did not change significantly from pre-works to post-works. The overarching or the overriding damage was still this enormous 6-metre crack underneath the wall. So it's, with respect, this is not a reference to new damage. This is a reference to the existing damage. I'm not going to spend too much longer on this ground. I think you've largely got my points on it. I think, in fact, I will, with your permission, move on to my ground in relation to costs.
Yes, thank you.
So, in respect of the original wall awards, the appeal before Her Honour Judge Backhouse and now, the substantive claim has always been for money and only money. And that's by way of compensation under section 7.2 of the Party Wall Act, and that subsection is precisely equivalent, in my submission, to the common law damages which the courts have jurisdiction to award at common law. under the original awards, the Joneses were to receive £215,316.28. The Spriggses £165,874.54, a total of some £381,000 odd pounds. After the appeal, before Her Honour Judge Backhouse, the Joneses were to receive £166,374.19, and the Spriggses £135,085.80, a combined total of £301,000 odd. So the appeals reduced the compensation awarded to the adjoining owners by some £80,000.
Can you just help me on this, Mr. Isaac?
Yes.
I'm not familiar with this statutory scheme. Is the position that once a notice of appeal has been entered, the surveyor's award is at least paused and everybody starts again from scratch?
No. It works in the same way as a judgment. An appeal against an award does not operate as a stay.
Okay.
Whilst in this particular case the respondents didn't take steps to enforce the award, it would have been the original award. It would have been open to them to do so.
But it's an appeal by way of rehearing.
Correct.
So although your client was the appellant, it was still, there was a burden of proof on Mr. and Mrs. Jones and Mr. Spriggs.
Correct.
To prove loss and causation before the judge, otherwise they get zero.
Correct.
Thank you.
I should point out, and this may be clear to you already, that on the appeal, which, as Your Lordship's already noted, it was by way of rehearing, the respondents were in fact seeking higher levels of compensation than they obtained under the original awards.
And I think that the applicant, or the appellant, was seeking pay nothing.
Well, nothing or less. Yes.
Well, nothing or less than nothing is nothing.
No, yes. The appellants there below and here, best case scenario, was zero.
Yes, and that's why there was all of the new evidence about the acacia trees and
Yes, correct.
things like that. Right. And was it the appellant's case that the appeal before Judge Backhouse should be by way of rehearing rather than review?
Yes. It's, and let me be clear that it is, and this goes back to the case of Zissis and Lekomsky, which if necessary, I can take Your Lordships to, but the normal appeal under Section 1017 of the Party Wall Act is a appeal by way of rehearing. So the vast majority of appeals under the Act are appeals by way of rehearing.
Yes, that may be, but it's obvious from the judgment in not the cost judgment, but the judgment under appeal in relation to causation, that the judge specifically mentions that directions were given, I think, by the designated civil judge, that it should be by way of rehearing in the directions, which is why she spent 5 days and made a site visit, etc.
Indeed. My lady, that is, it is absolutely standard at the beginning of an appeal under Section 1017 for the court to decide whether it's more appropriate for this appeal to proceed by way of rehearing or to proceed by way of review.
So is it right then that if somebody comes along in the case of Mr. Taylor and says to the judge, well, actually, I want it to be a rehearing because I want to have this root and branch. I know that's perhaps inappropriate in this case, but investigation.
Seems very appropriate in this case.
You know, if he was only looking to reduce the quantum of the compensation he must pay, then a review would have been just as
appropriate. No, it would not have been as appropriate.
I see.
The basis upon which the quantum was reduced was the evidence of a joint evidence of a quantity surveyor in relation to quantum. So no, the evidence was absolutely necessary in order for us to succeed on the reduction in the quantum as well. I felt slightly bad about adding a further authority to your lordships because we already had quite a few in, but I sent the case of Triumph and...
Oh, this is Mrs. Justice Farrell's case. Yeah, I'm not sure why you've put it in, because doesn't she just reiterate the principles that are...
Well, she reiterates the principles, and the reason I've put it in is because she reiterates the principles, so I don't have to take you to half a dozen authorities.
I see. Okay.
And there's a few points I wanted to highlight from the principles.
Sorry, if this is a supplementary authority, I haven't got it. But, maybe my fault.
I've got two copies here.
Well, I've got it online,
You've got
so my lords can have it if that's
I'm grateful.
helpful.
Thank you very much.
And it's fair to say fundamental to this ground of appeal is I say the judge was plainly wrong in her decision as to who the successful party was. And let me explain by reference to some of the quotes from Triumph why that's the case. She starts with the relevant legal principles at paragraph 7. Obviously, one of those under CPR 44.24 is whether a party succeeded on part of its case, even if it's not been wholly successful. And the general rule is that the unsuccessful party will be ordered to pay the costs of the successful party. At paragraph 12, in quoting from Straker and Tudor Rose, and the approach that Lord Justice Waller suggested should be taken, I would refer you to the quoted paragraph 13, where, particularly in a commercial context, the claim is for money. In deciding who is the successful party, I agree with Lord Justice Longmore when he said in Barnes and Time Talk that the most important thing is to identify the party who is to pay money to the other. In considering whether factors militate against the general rule, applying clear findings on necessary factors which led to a disapplication of the general rule. That bit I can ignore. So paragraph 13 of this judgment, little 1, quoting now from Mr. Justice Jackson in Multiplex Constructions, UK Limited and Cleveland Bridge. 1, in commercial litigation where each party has claims and asserts that a balance is owing in its own favour, the party which ends up receiving payment should generally be characterised as the overall winner of the entire action. In considering how to exercise its discretion, the court should take as its starting point the general rule that the successful party is entitled to an order for costs. The judge must then consider what departures are required from that starting point. Then, I don't need to take you to any of the rest of that paragraph. And then, paragraph 14, quoting from Mr. Justice Sales, as he then was in F&C Investments against Barthélemy. it's frequently a feature of litigation, particularly of complex, hard-fought commercial litigation, such as in this case, that arguments or factual disputes may be relevant to a number of underlying issues which have to be addressed in the proceedings. It's also frequently the case that a party may rely on a number of grounds to support his claim that he was entitled to take some particular action and succeed in showing his entitlement so to act, while at the same time losing the argument that certain other grounds relied on by him provided a proper basis to justify the action on. 19. In exercising its discretion as to costs, the court will be cautious before concluding that an award of costs in favour of the party who has won overall should be limited in either of these cases. This is a function of the general approach the court should avoid an unduly finely detailed division of issues and sub-issues when deciding what costs to make. General rule is that the unsuccessful party will be ordered to pay the costs of the successful party. Often it will be appropriate that the winner should get an order that the loser should pay his costs, even where there have been issues on which the overall winner has lost. And then perhaps 21 as well, parties should be afforded a reasonable degree of latitude in formulating claims, including pleading alternative basis for the same basic claim. That is a normal and reasonable way to conduct litigation. Those are the key points out of the authorities, I would suggest here. And that is primarily setting out the position at first instance. So that is not dealing with appeals per se. And I don't think any of that is contentious between the parties. Where we differ is that on appeal, in my submission, where the claim, the underlying claim, and the appeal, therefore the appeal, is about money and only money, the decision as to who has won and lost has to be decided by reference to the decision prior to appeal. It can't, as my learned friend would have it, be reset as if the original decision had not happened.
But in this case, you've just said that your best case scenario was that you should pay nothing or less than nothing on the basis that it was the tree roots that had done the damage, not the party wall work. We're not in this territory that you're positing, are we?
With respect to, we absolutely are.
But it wasn't just about money, that appeal before, that hearing before, Her Honour Judge Backhouse?
It was absolutely about money. No other remedy was sought by the respondent than money.
Well, in that respect, yes,
So when
you were seeking, by virtue of the appeal, to persuade the judge that nothing that had happened in respect of number 5 and number 6 had anything to do with the party wall works.
Absolutely. We were looking to do we were running two alternative cases. Either our works did not cause this damage,
right,
or if they did cause this damage, the quantum of compensation which the third surveyor awarded was too high.
Right, I understand that. But the first case that you were, or one of the two horses that you were running, was on causation.
Correct.
It wasn't just on quantum.
No, but that's, with respect, that is not what the authorities on costs are addressing. They are addressing the question of whether a claim, because any claim involves a claim, has to involve liability, which involves causation. So
I understand that.
So surely, there's nothing very novel about this. Your client was, in effect, appealing liability, causation, everything. If it had just been an appeal on quantum, the hearing before Judge Backhouse would, I assume, had lasted nowhere near 5 days.
it would have been shorter.
And the costs of that hearing were what? $250,000 each side, or
Yes,
something?
and some, yes.
And some. So you're saying that your client appealed everything,
Correct.
achieved a reduction percentages which the judge set out in the quantum award, lost everything else, and the Jones and the Spriggses should have to pay your client £300,000 in costs because of that small reduction.
Well, it is open to, let me take it stage by stage.
Yes.
The starting point, I understand the point that your Lordship is making, but the starting point for assessing costs is to decide who has won. And when a claim is for money, the decision on who has won must follow the money.
Sometimes. Suppose the judge had made an issues-based order. Could have gone into how much of the 5 days was spent on arguments of law, how much was spent on evidence about causation, and so on.
No, I entirely accept that.
Yes.
But the starting point, and so the judge in this case decided that my client had not won, that they were not the successful party. What your Lordship has just raised is not step one, but step 2 or 3 or 4. It's deciding when you have determined who the successful party is, should there be a departure from the normal order, which is that the unsuccessful party pays the successful party's costs.
Yes.
So that's a separate question. So where the judge went wrong here, clearly went wrong in my submission, was that in a case which was about money and where there was a decision, a previous decision, which set the amount of money, we just look at the award.
That would have been fine and dandy, Mr. Isaac, if you'd gone in front of Judge Backhouse and said, look, we accept that the party wall works caused damage, but the real issue here is this underpinning that's necessary. And we say that's pre-existing damage, just as you've been saying to us, that's pre-existing damage and it should not be compensated. But that wasn't the case that was run before Judge Backhouse. What was being said before Judge Backhouse is that there are 4 acacia trees down at the backyard. They've caused damage. Nobody now plants acacia trees. There's botanical advice saying, or arboretal advice saying, do not plant near to fences or houses or whatever, because we don't know what's going to happen. And there was a full investigation about this. And the judge was required to make findings of fact based upon the expert evidence in that regard. No, it was your client's option to run that case on liability or causation. And you can't just say, well, forget about it.
Yeah, and my lady, I am not suggesting that that should be forgotten about. That should clearly be taken into account in the award of costs. But
all right, so if we do take it into account, or if the judge at first instance takes it into account, you'd accept, would you, Mr. Isaac, that she would be entitled to say, in that regard, Mr. and Mrs. Sprigg and Mr. and Mrs. Jones have won. They are the successors because they have established that there is compensation due by reason of the party wall works.
well, the way I would characterise it, I would say that in a multifaceted appeal, and this was a very complex case in the same way as the authorities are talking about complex commercial litigation. This was factually and from an expert perspective very complex. So let me remind your ladyship that the original award suggested that our works had caused the 80mm crack in the rear wall.
You don't have to persuade me. Certainly you're pushing it an open door so far as I'm concerned, Mr. Isaac, that this was a factually complex case for the judge to get to the bottom of.
So it's
And she did. But that doesn't obviate the fact, and I'm not saying that it was unreasonable for Mr. Taylor to pursue the case that he did, in the sense that he got expert advice, or appeared to have expert advice, that gave him some ammunition in that respect. But once you get to the findings of fact made by the judge, she was against Mr. Taylor.
I accept that she was against Mr. Taylor, but so one can characterise it in various different ways. But this was not a separate appeals. This was one appeal, a multifaceted appeal, in which we said either we didn't cause this damage, or if we did cause the damage, the award of compensation is too high. Now, it would have been open to, in the same way that your ladyship suggests Mr. Taylor could have decided not to pursue the causation argument. Absolutely correct. Equally, the respondents could have conceded the quantum argument.
Right, so do you want to take us to the judgment where you say that she went wrong?
Yes, very well.
We've got two.
You've got the redacted and unredacted.
Is there any reason for us not to look at the unredacted bundle?
My only slight concern is without the determination of the question of the substantive issue could potentially impact.
Well, if you'd rather we looked at the
I don't
redacted
think
bundle.
it's going to make a difference.
Well, there's no difference in the judgment, is there?
I don't think that. I don't
No.
think.
I thought there were a couple of paragraphs which were left out.
No, I think that's in the submission, so it's my fault. Yeah, I think the judgment is the same. Is that right, Mr. Isaac? The judgment is the
There are
same?
no, my lord. Justice Bean is right. There are a couple of paragraphs that I think it's 11 and 12 which are redacted.
Well, I'm afraid I've read
You've read
the full text with 11 and 12, but this isn't an appeal on quantum, so I couldn't quite see why we shouldn't read.
Should we deal with the
I
unredacted?
think it was my Lord Justice Nugee, in fact. who
I'm
was
sorry.
right about, just so that you've got your right on
I'm
that.
sorry,
Correct, Mr. Isaac.
I'm sorry. Let's look at the.
So which do you want us to look at, Mr. Isaac?
Yes, sorry, I'm just.
Does it matter?
I don't think it matters too much.
No, okay. So we've got the judgment, and you're going to show us where the judge went
Yes.
wrong.
So she correctly says, I'll start with what she's right about. She says, she quotes at paragraphs 9 and at paragraph 9, as the notes at 44.2.13 remind me, CPR 44.22 poses two questions. Who is the successful party and who is the unsuccessful party? And when should the general rule be applied or not applied? She deals in the redacted, we don't need to deal with that. She then at paragraph 13 talks about conduct, says there's nothing in that. So paragraph 16, that leaves all the circumstances, including the extent to which a party has succeeded in part, if not wholly. Looking at this issue, it's clear that the appellant has succeeded in reducing the amounts originally awarded. And then she says, the respondents at 18, the respondents on the other hand have succeeded in fending off a number of robust legal challenges to the proposition that the appellant should pay them for the damage at all or to any significant extent. So they succeeded on the central issue of causation and on the pre-existing damage point. The other two issues raised by the appellant in the grounds of law, namely applicability of the Act of Foreseeability, were both abandoned shortly before trial. Where she goes, and when she then says at 19, standing back, I consider that the respondents are overall the successful party. I say that is not a conclusion she was entitled to reach, because the fundamental question of success on an appeal, where it's about money, is have you improved your position financially or not on the appeal? And that follows, as night follows day, from the authorities, the first instance authorities, as to how do you judge a winner? How do you judge the successful party? One cannot say that the appellant here was unsuccessful, the unsuccessful party, where they have succeeded in overturning the decision and reducing the amount awarded.
Mr. Isaac, suppose that one crossed out the first sentence of paragraph 19. What about the second sentence?
Well, with respect to Her Honour Judge Backhouse, that is an attempt to ignore the consequences of the basic rule. It's I accept that a judge, when determining the issue of costs, is entitled and should take into account all of the relevant circumstances set out. So conduct, as she talks about conduct, and should consider the possibility of, say, an issue-based cost order. So it would have been open to her, having determined that we were the successful party as the starting point, to then have said, well, strictly speaking, the appellant is the successful party, and so the basic rule is they should have their costs. But there are factors here which mean that I want to depart from that. That would have been entirely reasonable. But, and she might have said, and as your Lordship suggested a moment or two ago, that an issue-based cost order might be appropriate because actually more time in the action, more time in the appeal was taken up with the question of causation, more time and money was taken up with the question of causation than the question of quantum.
Well, in that regard, I mean, paragraph 5 is also against you, isn't it, Mr. Isaac? Because what she says is, it was an issue which the respondents would have to prove, even though I accept, and Mr. Isaac accepts, that the appellant did not formally raise quantum as a separate ground of appeal or identify it as a particular issue at the pre-trial review. So, I mean, it looks as though the judge was under the impression that this was a byproduct, not, as you were saying, a two-horse race. What does she mean by paragraph 5, if what you're saying now is correct?
Well, the judge accepted, the respondents took the position that we were not challenging quantum.
Yeah.
The judge accepted that we had always intended to challenge quantum.
Well, no, that's not what she says. She said, whatever the respondents believed up to September 2022, the quantum of the awards was always, in my judgment, an issue that the court would have to consider. It was an issue which the respondents would have to prove, even though I accept, and Mr. Isaac accepts, that the appellant did not formally raise quantum as a separate ground of appeal or identify it as a particular issue. As Mr. Smith says, rightly in my judgment, the burden of proof was on the respondents to prove all parts of their case at the rehearing. So I'm just wondering whether or not that fits in exactly with what you're saying.
Well, it's something of a distraction from the. I'm just looking for the original grounds of appeal under the. Under the awards, which I think are in the main bundle.
Right.
The original ground 4 was the third surveyor erred in awarding the respondents compensation for damage to their property.
But that's said to follow from grounds 1 to 6.
Yes, I understand that.
So if we look at the six grounds of appeal,
Yep.
page 117 in the main bundle. One is causation. 2 is not notifiable works. 3 is whether the works were carried out in accordance with the awards. 4 is erring in awarding compensation, but it's said to follow from above. And then 5 and 6 are costs, which are again said to follow from above. So the judge is right that you didn't say in your grounds of appeal, even if we're wrong on liability and causation.
It was not pleaded in that way.
It was not pleaded in that way. Why can't the judge therefore take the view that the issues on appeal were really liability and causation, and on those issues you lost and the respondents won? As she says in paragraph 5, as my lady has pointed out, she accepts that quantum is always an issue because the respondents have to prove their case because it's a rehearing, so they've got to prove everything. And so that enables you to take points on quantum, which you did take. But that wasn't, in her estimation, what the appeal was really about. And why is that not an inappropriate way for her to look at it? I understand your point that you succeeded in ending up paying less money. But the question of whether someone is a successful party has been said to be, in the end, you have to stand back and look at things in the round and take a common sense view of it. That's what Lord Bingham said many years ago. Why can't she take the view in these particular circumstances that the appeal wasn't really about quantum, it was really about liability?
Well, I come back to the point that we are looking, when one assesses success in relation to a claim which is a money claim.
Yeah, no, I have that point.
It is not.
Your point's a very simple one, which is if we hadn't appealed, we'd have to pay 380,000. We've only got to pay 300,000, so we won.
Correct.
Yes, and she understands that because she says,
well,
I accept. It is clear the appellant has succeeded in reducing the amounts originally awarded, and then she gives the percentage reduction. So it's not as if she's failed to understand that. Your point is that should have been the end of the inquiry.
No,
on who is the successful
yes, indeed.
Who is the successful party?
Correct.
And what I'm putting to you is that, given the way in which the case was pleaded, why can't she quite properly say, I think the pleaded issues were about liability and causation, and on those issues, the respondents were successful, and so I regard them as overall successful, even though they've ended up getting less money. So even though you had to appeal to reduce the amount, and even though to that extent you succeeded, that wasn't really the heart of the appeal. So what's wrong with her taking that view?
Because that is moving inappropriately away from the test of success based on who's paying. So the wider test that Your Lordship is talking about, as to one must take a common sense view as to who has succeeded, is appropriate where where what is in issue, where the remedies sought are wider than merely money.
In a money case, success is simply, have you cut down the amount?
Yes, on appeal.
On appeal.
On appeal.
Yes.
Have you cut down the amount? That can be the only measure where that's the sole remedy. This was not a case about whether a particular kind of repair would have been more appropriate or less appropriate in the sense of an injunction or anything like that being an issue. It is solely about money. And if it's solely about money, the sole determiner of who has been successful is whether they're better off or worse off than they were after the initial decision.
Mr. Isaac, when you talk about a case being solely about money,
Yes.
you're talking about remedy.
Correct.
Not about the issues in the hearing.
Correct.
That's what you're doing.
Yes.
I see.
Because there are, in any case involving money, there are going to, well, I suppose there are some cases that are solely about quantum. That I accept that that's a possibility. But most commercial cases are not solely about quantum. They're about many issues of liability, causation, etc. So the authorities I've taken you to in relation to the question of costs have boiled down to, when it's just about money, success is measured in money terms and solely in money terms.
And those authorities that you've taken us to, do they make the point that you make, that when you say if something's solely about money, it's about remedy, not issue?
Well, I would say yes. I would say that it's implicit in the extracts I took you to.
I see.
When they say a complicated commercial case, that's not a complicated commercial case solely about quantum.
Right, but you accept that there are cases that come before the courts below and before this court that are only concerned on quantum.
Occasionally, yes.
All right, thank you.
So, assuming I'm right about the basic test of success, then the judge goes through a process of deciding whether there are reasons why you should depart from the general rule. And I fully accept that there were potentially circumstances here which would allow her to do so.
What order do you suggest, if you are right, should be made?
I suggest that your lordships should order that the respondents pay the claimants an appropriate proportion of their costs of the appeal. And
In this court?
no, below. I'm talking
Below.
And do you put a figure? Because you don't, in your appellant's notice, you just ask for the respondents to pay your costs of the appeal
Yes.
below.
Yes.
But I think you've accepted that the judge could have
Indeed.
properly departed from that and only awarded an appropriate proportion of your costs. Do you
Well,
put a figure on that?
I would venture to put a figure of, but I accept that it's really for your lordships. I'd venture to put a figure of, say, 50%. Because
is there any science behind that, or is that just a finger in the air? The difficulty for us is we didn't hear the appeal, so we don't know how much time was taken up cross-examining experts, how much time was taken up, how much expense was spent on arboricultural experts and so on. It's quite difficult for us, is it not?
Well, yes, it is somewhat difficult, but it's not impossible. It's not. I'm sure it's not beyond your lordship. What I would say, a point I should perhaps have made immediately after the success question, is that it was open to the respondents to protect themselves from an adverse costs order by making an offer, an issue-based offer. They could have offered, if they were convinced that they were right on causation, they could have made an offer in relation to causation or in relation to quantum only.
Well, they did make an offer.
Yes, they did make an offer, but they didn't make an offer which fit.
Sorry, they didn't make an offer.
They didn't make an offer which was a relevant offer in the sense that...
well, paragraph 11 of the cost judgment, the respondents offered a reduction in the award and that they would pay the appellant's costs of the appeal at a very early stage in the appeal.
Correct. So that, I would... So 2 points arise from that. We're now, you're now looking at the unredacted.
Well, you said we could.
Yes, fine. But well, let's look at it. So,
well, we have.
Yeah.
You said we could, or you offered no objection as to why we shouldn't. And of course, now that you're making the submission that the respondents could have made an offer, it becomes very relevant. And even if you'd not said that you did not object, I'm sure that Mr. Smith would say, well, hang on a second. This runs counter to what he's saying.
So,
Can we just check that Mr. Smith doesn't object to us looking at the unredacted material?
No, I don't.
No.
that's very helpful to everybody. So they could have made an offer which would have protected them. They made an offer which didn't protect them because it wasn't sufficient. But your ladyship will notice that the offer referred to was an offer which reduced the amount and accepted liability for our costs of the appeal.
Yes.
And you refused the offer.
You turned it down.
And we were right to do so because the offer of a reduction of 15,000 or whatever it was significantly less than what we achieved on the appeal.
Well, I appreciate what you're saying. It's winner takes all. Bang. If you achieve a modest reduction in the appeal, then you'll stand before the judge, and until my lady asked you a question was, you get everything. Ta-da! And
well, and that is
that's litigation.
That's litigation.
Yes.
And of course, I accept that the judges have discretion then to adjust that. But nonetheless, that's the basic rule. If no offers had been made here, we'd still be in the position, because the offers that were made didn't bite, we're in the position where we have succeeded on the appeal. However you look at it, in money terms, we've succeeded on the appeal.
I don't think that's right, whichever way you look at it, because one of the ways of looking at it is that you failed on the appeal because one of your strands of argument, and one that was actually and actively pursued, was we shouldn't pay anything. So it's not whichever way you look at it, we've won. You haven't. You have succeeded, as my lord says, in reducing the award from the surveyor in the first award by a realistic amount. But you're cherry picking a bit, aren't you, Mr. Isaac?
Well, with respect, I'm not cherry picking, because all I am doing is suggesting that the judge should have approached this by reference initially to determining who was successful, and the only conclusion she could have reached in that regard is that it was us because of the money.
All right.
And then she is entitled to consider whether an issue-based cost order might be appropriate, because we had spent significant time and money in pursuing an unsuccessful ground. But so there was potential for an issue-based order. But if she's taking a proportionate approach, and looking back again to the authorities quoted, and in particular Mr. Justice Sales's comments, there has to be, you have to give the successful party quite a significant leeway in terms of what they might have argued and argued unsuccessfully, because all litigation involves complex interwoven facts.
Well, that's fine in certain respects, Mr. Isaac, but paragraph 18 of the judge's judgment describes causation and the pre-existing damage point as the central issue. And on that basis, if you've got somebody succeeding on the central issue, doesn't that come into the accounting on one side or another pretty significantly?
Well, it could. So I accept that if that, and I even accept, what she says about it being the central issue. It was. It took up more of the 5 days than the quantum issue. But the conclusion to be drawn from that, the worst case scenario from my client's perspective, the worst the judge could have done to us is to say that the appropriate order was no order as to cost.
Why do you say that? Why could she not say if she made an issue-based order? I think that the appellant should pay the respondent's costs of causation and damage. So all the experts and all the time taken up with cross-examination of the experts and all the arguments on liability and causation. And that the respondent should pay the claimants only the costs, the extra costs incurred in running the quantum argument, which I assess at a very small proportion of the overall costs. Could she not have done that?
She could have made an issue-based costs order along those lines. I accept that she could have made an issue-based, and that, I suppose, potentially, that might have had the effect of a net payment to the respondent. But that's speculation. She didn't make an issue-based costs order. She took a proportionate approach. But the proportionate approach that she took was based on a misconception, namely that we had that the respondents had won, but that we had succeeded on, let's say, 1 out of 4 grounds, and therefore she would give them 75%. Well, if to use her analysis and to say what conclusion should she have drawn in the circumstances, the correct analysis would have been, on that analysis, we won, but we lost on, or we only won on 1 out of 4 grounds that we pursued, and therefore we should only have 25% of our costs. So that would be the appropriate analysis based on her reasoning?
Well, the heart of her reasoning is that she held that it would be profoundly unfair and artificial to follow the course you were proposing. And you say that that's a conclusion she was not entitled to reach.
I do say that's a conclusion she was not entitled to reach.
Made it clear enough.
Because she is not entitled to simply ignore the approach to costs which have been laid out quite clearly in the authorities and in the White Book. So if she misapplies those rules, that's wrong. Unless I can move any further.
No, thank you very much, Mr. Isaac. Do you follow, Mr. Miller?
No, my lady, I have nothing further to add.
Thank you very much. Mr. Smith?
My lady, I was going to...
Why don't you pick up the reins where Mr. Isaac's just dropped them and deal with this cost
on the issue
point
of cost...
whilst we've got it fresh in our brains.
Yes. We say that the court obviously has a broad discretion, and the decision that she reached was entirely within her discretion. Mr. Isaac's case is really based on an assertion that she was simply wrong in law in regarding the respondents as a successful party. And we say that that's not right. There is no rule of law that says that in a case of this sort, the appellant who gets something off his damages is the successful party. And there are really various reasons for that. The judge identified 5 issues, and my Lord Justice Nugee went through those, and all of the issues that were in the grounds of appeal we succeeded on either at the trial or because the appellant abandoned them. The only one that it might be said there was a real issue about was when it said that the third surveyor was wrong about causation, but that was always said to follow, about damages, but that was always said to follow from the above, i.e. all the points that they lost on. Until 3 months before the trial, you'll see that the judge refers to September 22. That was when the appellant suddenly woke up to a potential quantity question and made the application for a joint quantity surveyor, and the judge allowed that. The only issue before the third surveyor was causation. No issue on quantum or anything else was raised, it was only causation. That was really the case until September 22. And on all those issues, we succeeded. Now, the reasons really that we say that the appellant is wrong in saying that any reduction is sufficient to treat him as the successful party are these. First of all, as you've already identified, the judge was correct that the judge found that it would be profoundly unfair to treat the appellant as a successful party, and we say that weight should be given to that. Her assessment, standing back and taking everything into account, was that the respondents were the successful party. It would be highly artificial, we say, to say that because of a reduction in the quantum, her analysis was flawed. The second point that we rely on is that the appellant's main case was that we were liable for nothing because they didn't cause any loss. That was the principal case, as the judge upheld, and the judge rejected that argument. The third point is the nature of the appeal to the judge. As I said, the appeal to the decision by the third surveyor turned solely on causation. The appellant lost on that, exercised the right to appeal, and we had what was effectively, we say, a trial. Although the Party Wall Act gives a right of appeal, and it is as an appeal, and I accept that. Effectively, this is the hearing before Judge Backhouse is the first occasion on which there was a trial of the issues. The reason that there was a review was that everything before the third surveyor was dealt with by way of submissions from surveyors in writing. There was no trial. The hearing before Judge Backhouse was the first time that there was what was an effective trial. And we say that given the nature of a party wall appeal, where effectively a losing party has a right to appeal to the county court, although it's an appeal, it is effectively the losing party saying, I wish to exercise my right to move away from the summary determination of a third surveyor and actually have a trial in court. So we say that it isn't at all unreasonable to say that although it's an appeal, a judge that's hearing an appeal and dealing with it by way of a rehearing is effectively conducting a trial. And therefore, when you are standing back and looking at who is the successful party, well, of course it makes sense to say the successful party is not simply the person that gets a little bit off. It is who is actually the recovering party. When it's a full rehearing, who is the recovering party? And it is, in our case, we're the recovering party because, as your ladyship said, on a rehearing, we had to prove our case afresh. Therefore, I accept all that my learned friend says on the Triumph case and the basic principles, which are very well known. But the reality in this case, as far as the judge was concerned, was that she was doing a trial. We were the party that were seeking to establish our case, and we succeeded. It would, if my learned friend were right, one would have the rather extraordinary situation, we say, that effectively we're standing in the position of a claimant having to prove our case on a rehearing. And any reduction in the amount claimed means that we are the losers, and that is a very odd position to be in. We say the only way someone that's effectively having to prove their case in order to recover anything can protect themselves is to make an offer, reverses the usual position between the claimant and the defendant. So we say that you have to take into account the nature of the appeal in this case, which is that it was a rehearing and effectively we were standing in the position of the claimant. And when my learned friend says you follow the money, following the money is effectively we succeed in establishing that we are entitled.
Is this right, Mr. Smith, that at the trial, the findings of the third surveyor, if that's the right way to describe them, don't have any particular status? That the parties have to, your clients had to start again.
Yes. That's the position. And that's why I say effectively the appellant opts to have the case tried in court rather than simply accepting the determination of the third surveyor, which doesn't have a trial and only goes on, in this case, written submissions by each party's surveyor to the third surveyor.
Well, the judge deals with this in paragraph 4, doesn't she? The nature of the hearing.
Yes. And indeed, the oddity of my learned friend's position was that we opposed any quantum evidence being adduced because we before the third survey we had provided tenders and quotations.
You took a pleading point, didn't you? You took a pleading point, effectively.
We did. We took a pleading.
And the judge was against you on that.
The judge was against
Yeah.
us because there was a reference to quantum. But she also said that given that this is a rehearing, we had to prove our case afresh.
Yes.
And that's why she then, at the late stage, allowed quantity surveyor evidence in. So my learned friend was using the fact that it's a rehearing and the burden of proof is on us in order to justify getting the quantum evidence in. And then when we get to trial and he reduces it, he says, well, no, you can't really take account of the fact that the burden of proof is on us. It's simply an appeal and you get a reduction on the appeal. And that is, that we say is wrong.
So that's 3 points. You said you got 5.
Yes.
Or perhaps you've wound them up in number 3. I don't know. 4 and 5.
There is another point that I would make, and that on costs, and that is section 1017B. It's in the of the Act. It's in the bundle of authorities at page 18.
Thank you.
So section 10 is the section that deals with resolution of disputes and requires the parties to appoint surveyors and provides that the surveyors can make an award. And then section 1017, either of the parties to the dispute may, within the period of 14 days, beginning on the day in which an award is made, is served on him, appeal to the county court against the award. County court can rescind or modify it in such manner as it thinks fit, and B, make such orders to cost as it thinks fit. And that was considered in Sissi Lukomsi, as Mr. Isaacs said, and the court said that because you haven't had a trial, generally you will have a rehearing of the matter, and that's what's ordered in the But section 1017B doesn't provide. It envisages an appeal in court, but it doesn't simply leave that to be dealt with as an appeal in court. It expressly makes provision that on that appeal, the court can make such order as to cost as it thinks fit. So in a way, that could be seen as stepping away from the usual rules of court and the principles that apply in court in relation to a party wall appeal, and says that the court can make such order as it thinks fit. Now, of course, any court can always make such order of cost as it thinks fit, subject to applying the usual principles. But what we say is significant in this case is that in the case of 1017B, is that the Act didn't need to say anything at all about costs. It could have just left costs to be dealt with in the usual way, but it didn't. It made it clear that the court can make such order for costs as it thinks fit. And that is exactly what Her Honour Judge Backhouse did, and did so carefully in producing the judgment that she produced on costs.
Does it take your argument any further, though, Mr. Smith? Because even if it's stated that the court can make any provision for costs that it sees fit, it's still got to act reasonably and rationally.
It does.
And that's really what the rules are saying, isn't it?
That-
That's the point of Mr. Isaac's.
I suspect that is what the yes, that is what the rules are saying. But Mr. Isaac is inviting you to start from a premise that whenever there is a reduction, then the court is bound to treat the party that gets the reduction.
Yeah, we're hearing your submissions now.
Yeah. I am saying that that's not right, and I say that 1017B offers some further support for that.
All right.
Of course, the court has got to exercise its discretion properly. But the reasoning of our Honourable Judge Backhouse, we say is not only reasonable but clearly right in the circumstances. I think that's all I wanted to say on the principle of costs.
Can I just check?
Yeah.
You accept what Mr. Isaacs told us, that an appeal doesn't operate as a stay on the award, and that it's open to someone with the benefit of an award to enforce it pending an appeal. Is that right?
I do accept that an appeal doesn't stay an award. That seems to be. I don't think there's any authority on that, but that seems to be the general view. Although.
Well, isn't that the general rule of appeals, that unless a stay is ordered?
Yes, it is. In fact, His Honour Judge Parfitt had a practice of simply ordering a stay as a matter of course. And I was just trying to remember, he's varied that recently, and I was just trying to remember why, in case it bore on your ladyship's point, but I can't bring that to mind.
I ought to know this, but I don't. If a third surveyor makes an award, it's not obviously like a judgment in the sense that you send a letter of demand and then send in the bailiffs. I used to practice in employment tribunals, and employment tribunal may make an award of X thousand pounds to a claimant, but it isn't self-enforcing. You have to make a special application to the county court. Is there something like that for a third surveyor's?
My lord, yes, that's right. In terms of the award by the third surveyor, it couldn't be enforced without an application to the county court or an application to the magistrates court. Either of those would doubtless be met with a contention that shouldn't enforce this because there is an appeal. Yeah. The circumstances in which a stay is needed is when an award is made that permits work to be done, and then, in principle, the building owner can get on with the work unless there's a stay. Mm-hmm. But in practical terms, in this case, yes, it couldn't be enforced without a further application to the court.
Thank you.
Does that answer your point, Christopher?
Yes.
Yeah.
Thank you.
My lord, that's my lady. That's what I wanted to say on cost. Should I turn now to
Anything further on costs? Anything further on costs, Christopher? Yes, do, please.
Oh, well, no, I suppose we ought to ask you. Suppose that Mr. Isaacs persuaded us that the costs order can't stand. What do you say we should do?
Well, my lord, it's difficult because obviously Her Own Judge Backhouse heard everything. We say that even if the judge got it wrong and ought to have treated the appellant as a successful party, we say that there should still be an award of costs in our favour for various reasons. The principal claim was causation, as you identified from the judgment. That was the only issue until September 2022. There were 4 experts that were called to deal with causation. The large part of the trial dealt with causation.
Some of the experts were cross-examined. Not all of them, I think. How did the trial go?
All the experts were cross-examined.
All the experts.
All the experts were cross-examined. The trial went that we began with the engineering experts. They gave evidence.
They were largely agreed.
They were agreed, but a lot of time was spent cross-examining them because Mr. Isaac wanted to establish that in fact it was the trees and that they were wrong on their conclusion. So notwithstanding that the experts eventually were agreed, they weren't originally, but eventually the experts did agree. So notwithstanding that the experts were in agreement, there was still lengthy cross-examination of the expert engineers.
And do you say they gave evidence jointly?
They gave evidence. They were in the witness box together.
Yes.
But each was cross-examined with the other having the opportunity to jump in. It wasn't a traditional hot tubbing of a list of issues and the judge going through the list of issues.
It seems to be an idiosyncratic procedure in which 2 witnesses were cross-examined simultaneously.
Yes, it was. And
With the agreement of the parties?
With the agreement of the parties.
Yes. Presumably you didn't have much cross-examination?
I didn't have very much cross-examination.
No.
Not very much. So my recollection, and time was gone, but my recollection is that the engineering evidence was the lengthiest. There was then cross-examination of the arboricultural experts. They didn't agree, and that was also reasonably time-consuming. And then we had the single joint expert, which was on quantum, which was really me raising such questions as I was able on the quantum report.
And there was no non-expert evidence?
There was non-expert evidence, yes. My clients also gave evidence because...
What was that directed at?
That was... as far as the witness statements are concerned, it didn't really go very far, but Mr. Isaac had raised additional points in his skeleton argument that dealt with failure to mitigate.
I see.
So there were some questions on mitigation. And
Well, they were also asked about their knowledge of the damage, weren't they?
They were asked about
because
their
the
knowledge
judge
of
made a
the
finding in
damage.
their favour. She accepted their evidence
Yeah.
at that point.
I think she did find a slight failure to mitigate.
She did.
Yes.
She held that we ought to have done the works earlier.
But you had not adduced sufficient evidence of impecuniosity to excuse you from getting on with the work.
That's right. Yeah.
Yes.
Yeah. That was the conclusion that she reached.
So we have 5 days of trial. It may be difficult for you to remember, but do you remember how much of that was evidence and how much was submissions?
I think the final day was submission.
Yeah.
So 4 days of evidence and a day of submission. And the submissions obviously covered liability and causation as well as content.
The submissions I think were principally on liability and causation, but there were also they did cover quantum as well, at least from my perspective, because I was trying to do what I could with the single joint expert.
Thank you.
My lady, so on ground 2, the we say the start. I'll pick up my skeleton really. Paragraph 14. We say that the starting point is what is the nature of the entitlement under section 7.2. We say that although the principles may overlap, section 7.2 isn't actually a common law claim. Section 7.2 of the Act is at page 13 of the building owner shall compensate any adjoining owner and any adjoining occupier for any loss or damage which may result to any of them by reason of any work executed in pursuance of the Act. We say that the 1996 Act is a statutory code which generally supplements or supersedes the common law. I referred in the skeleton to Group 1 investments and keys, which is at tab 12, page 193 of the bundle. And I refer to that really because it was quite a convenient summary in paragraph 2 on page 194, where 4 lines down, the scheme operates outside the common law. The purpose of the 1986 Act to provide a simple and relatively inexpensive statutory dispute resolution, which, when provisions of the Act are operated, supplants respective common law rights and replaces them with rights under the Act.
Why was the Act needed? The problem with common law is if you've got a party wall, it belongs to both parties and they have to agree to any works, is that right?
I think under the Law Property Act 1925, party walls are deemed to be divided longitudinally.
Yes.
And therefore there were that severely curtailed the
Well, you've got a
parties' rights
trespass
to do
problem.
anything.
You've got a trespass problem,
Yeah.
but you also have a nuisance problem if you undermine a party wall. And
Yeah.
so
Yeah.
it's really intended to provide a code which replaces. I mean, the common law rights are perfectly understandable, but in practice they make it difficult.
Yeah, that's right. That's right. And
Am I right in thinking originally there was a Party Wall Act which only applied to London?
yes, the London Building Acts go back
The 18th century? Or,
Yes. And it was thought that they were a success, and therefore it was extended to the whole country. I was going to take you also, if I may, briefly to the case of Shah and Power behind tab 16 in the bundle of page 268. Paragraph 73. This was a case, it was a no notice, no act case. So it was a question of whether, if a party didn't serve a notice under the Act, whether the dispute resolution procedure in the Act still applied, or whether you were left to your common law remedies. And what was decided in this case was that you are left to your common law remedies if notice under the Act isn't served. The Act is only brought into operation by service of a notice under Section 2 in this case, or in our case under Section 6.
So why do you cite this case?
I was taking you to paragraph 73.
73.
Yeah, page 284. Because this, right at the bottom of the page, final 2 lines, the rights, those are the rights under the Act, once activated, superseded the common law, both as regards the building owner and the adjoining owner. So the adjoining owner's rights are under the Act. And then the other brief passage I was going to take you to was in paragraph 77, where Lord Justice Lewison quotes from Louis and Sadiq. And letter F is a paragraph beginning, "I would have no hesitation." And then the second sentence of that paragraph says, "The adjoining owner's common law rights are supplanted when the Act is invoked, which can have the effect of safeguarding the building owner from common law liabilities when he complies with the statutory procedures, just as he may incur liabilities under the statute which did not exist at common law." So I accept, of course, the principles of common law will always be relevant because they are looking at issues of fairness, but it is at the end of the day, we say, a question of really statutory interpretation of what Section 7.2 extends to.
Well, did Lord Justice Lewison accept what you've just posited?
Sorry,
in paragraph 78 he says, "The critical point here is that the adjoining owner's common law rights are supplanted when the statute is invoked."
Yes.
And until that time, the position remains governed by the common law of trespass and nuisance.
Yes,
But
that's right.
it's then the statute that...
Therefore, once a notice is served under the Act,
Yes,
the common law
that's the prism you look through.
you stop looking through the
Yeah.
common law prism once the notice is served. And it's a question of the interpretation.
And there was no issue in this case that the Party Wall Act procedure had been invoked by the proper service of notices, etc.
Yes, that's right. And it was service of a notice under Section 6 of the Act. And could I take you to Section 6, which is on page 11 of the Bible. So we were in the position of that Section 6.1 applies. The building owner proposed to excavate very close to the, excavate against the rear wall. And if you go down to Section 6.3, the building owner may, and if required by the adjoining owner, shall, at his own expense, underpin or otherwise strengthen the foundations of the building or structure. And the building owner exercised that right by saying that he wished to underpin the building. So the wall that was being underpinned wasn't a party wall, it was the adjoining owner's wall, it belonged to them. But the building owner, the appellant, had the right to come in and underpin our wall in order to facilitate the works that he wanted to do.
And he gave notice that he was going to exercise that right, did he?
He did.
Where do we find that?
I'm not sure that the notices are in the bundle, but there hasn't been any dispute about that. In fact,
I think the judge covers it, doesn't she, in the judgment?
she does.
There's a chronology somewhere, isn't it?
Yeah, I was just looking at that. I'm not sure that actually.
I'm not sure the chronology covers the relevant.
Party wall notices served on respondent.
Yes, 14th of April.
So paragraph 2, I'm sorry.
Sorry, it's slightly inaccurate terminology we're all using for convenience. It's not a party wall, but it's to wall in respect of which
No, it is
a notice was served under
It is-
Section 6 of the Charter
No, it is-
Rules Act.
It was served under. It was served under. There was no section 2. Section 3.
So is it paragraph 28 and 29
It
of
is.
the judgment where she refers to this notice, in effect? And then we see paragraph 32, awards made on the 3rd of May 2019, which permitted A to carry out his excavation and underpinning work.
Yeah.
Is that it? Have you come to a conclusion on this particular point, or do you need to finish it off before we break for the short adjournment?
The point of referring to all this was simply to say that we aren't simply looking at an application of common law principles, but proper construction of Section 2. I think I can finish there because I was going to take you to the authority that my learned friend mentioned.
All right.
It would be a convenient point.
Good. So, right, thank you. May we reconvene then at 2:05?